Jacob Andrade.
And here we go. The tension is already thick. The defendant, Jacob Andrade, steps into the spotlight. But this isn't just about one man's case. It's about whether justice will bend or break under pressure. What's coming next will test patience on both sides.
We got an offer from the state that was a time limit. We conveyed that offer. I believe we have received all discovery. I've tendered a discovery acknowledgement to the courts. And I believe the client wanted to address the court, but he formally rejects the offer.
All right. So do you want a jury trial or a bench trial?
Ma'am, look, I feel like I'm being coerced into signing for something that.
No, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying.
This is big. Jacob claims he feels coerced into signing a plea. For context, pleas are supposed to be voluntary. If a defendant even hints at coercion, judges typically slow everything down to clarify the process. Notice how the judge immediately takes the role of teacher here, breaking down how indictments, discovery, and plea negotiations actually work.
So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty, it's just telling what you're charged with, it gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel...
Quick pop quiz for you. Would you rather have 12 random jurors deciding your fate, or put your future in the hands of a single judge? Thinking face, think about it. One path gives you numbers, the other gives you focus. Drop your choice in the comments.
So railroading is the state is not making an offer that you find acceptable, then to you that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here, we're here, whatever evidence is presented, and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically and normally, this is what usually happens. The state has to prove that it happened in Bexar County, because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
The reason why I don't want us to take what the state is offering me because it's, I don't think prison is.
Here's the
I
thing.
would recommend,
Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee.
Goof, the judge just hit Jacob with a reality check. Nobody wakes up and says, yep, prison is exactly where I belong. But that line also exposes the hard truth. The justice system doesn't run on feelings. It runs on evidence, charges, and consequences.
Nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They'd be like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state because ethically, I'm not supposed to hear about that.
They're not even trying to hear me. He's not even trying to hear me. That's why I wanted to dismiss.
Okay, so state, who's the state on this case with Jacob?
I confer with Jason.
All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
It's just the case that we discussed. Okay, yes, so thanks. But after conferring, no, Judge, that's the offer.
All right, so he's saying he's not going to change the offer that he has made.
In fact, Judge, just sorry to interrupt you.
No,
Judge.
no.
That would be today only offer since
All
would
right,
be
And
changing.
that's how I feel in track. Like,
all right.
I feel like I got an ultimatum. I feel like if I hired another lawyer, I have a better chance to, get a drug program because the whole reason why I'm not running from what I did. I
wouldn't seek further, but don't.
This is raw. Jacob feels cornered, convinced that if he had a different lawyer, things would turn out differently. That sense of helplessness is common in criminal courtrooms, but here's the twist. The system doesn't pause just because you're unhappy with your options. It marches on.
Accept any, don't admit any guilt. Just please don't say something. Your Honor, we were here in a prior setting earlier this week. He had some time to think about this.
Mhm.
I know Jason is leaving.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box and then I'll bring you back up at 10:30. And you need to let the court know whether you're accepting, if you've reached an agreement or whether you're going to jury trial. Those are your options.
Okay.
All right, thank you. All right, Jacob Andrade?
Yes, Your Honor.
Yes.
Mr. Andrade had time to think for you. He reasserting his position that the dismissal is not for the case, the dismissal is for counsel to be dismissed. He wants a new attorney, and we would ask just have this go to a jury docket.
All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last, counsel?
And here's the curveball. Jacob doesn't just want a better deal, he wants a new attorney. That shifts the case entirely. The judge now sets a jury trial, locking the path forward. October 28th, circle that date, because that's when this battle officially begins.
Check to say, is It's a $10.
Oh, that one.
3 days, Judge. I mean,
All right, Norma, 3 days. And it's criminal trial division. And counsel, if you make sure I have an acknowledgement of discovery, I think I may have one, but just double check.
That was tendered on Tuesday.
Okay.
I signed it.
All right, October 28th. All right, thank you.